Hello, my name is Mary Coupland and welcome to the Road Ahead. Through a series of guests, we are going to help you navigate your own road ahead as you age. We will help you and your aging parents prepare for your journey. Let's face it, nobody wants to find themselves in a crisis mode simply because they did not have access to information well in advance. As the publisher of Compass and Clock, we will help you achieve your best future. Today, our guest is Tony Hinson. Tony has over 22 years of legal experience, and he focuses on estate planning, elder law, estate and gift taxation, IRA trusts, and more. Also, as of February 1st, Tony is a retired veteran from the U.S. Navy. Tony, thank you for your service and for joining me today.
Thank you, Mary. It was an honor to serve, and thank you very much for having me as a guest.
I'm thrilled to have you here because today, Tony is going to help educate us on the Secure Act that went into effect January 1st, 2020. So, Tony, can you briefly tell us what is the Secure Act?
Absolutely, Mary. The Secure Act is an act that was put into place to reform retirement eligibility and availability for folks that work in the United States. It stands for Setting Every Community Up for Retirement Enhancement. Okay. So you can tell they were really going for the acronym there. What it does briefly, it expands access to 401k plans for people that work in smaller employers. So that's the good part of the act. The important part of the act, though, from the estate planning perspective, is that it virtually eliminates the stretch IRA. It changes dramatically how IRAs are treated by those who inherit them. It might be helpful for me to briefly go into the rules as they existed in the old days, and by that I mean December. Before, if you inherited an IRA and you were not a spouse, you could keep the money in the IRA for the rest of your life virtually and take it out in slow increments over your lifespan. The IRS publishes tables that tells us approximately how long they expect a person to live at a given age. And with careful management, you could take an inherited IRA and stretch that IRA out over the rest of your life, treating it virtually as an annuity. Unfortunately, for most people, the Secure Act ended that eligibility.
So it's called the stretch IRA because it was stretched out over a longer period of time. So with the Secure Act in place now, how does this affect a non-spouse beneficiary?
Great question. I guess I'll start off by saying with spouses, thankfully, the rules are unchanged. A spouse has the option of taking an IRA that they've inherited from their deceased spouse and rolling it into their own IRA, or in some circumstances, they can choose to pay the IRA out over their measuring life. However, for other people, for non-spouses, with limited exceptions, the IRS rules now require that IRA to pay out within 10 years after the person who passed left it to you. And that can be, for most people, a greatly accelerated payout. There are certain exceptions. One is a spouse. So a spouse can choose to draw the IRA out over his or her lifespan. The other are chronically ill or disabled individuals can choose to use their life expectancies as well. Okay. The thing there is the definitions of chronically ill and disabled are much tighter for the IRS than they are, for example, the Social Security Administration. The other would be individuals that are less than 10 years younger than the person who passed. And finally, minor children can keep the IRA in the IRA until they reach 18, at which point they've got to pull it out within 10 years as well. As you can see, this results for most people, again, in a greatly accelerated withdrawal from the IRA. And for traditional IRAs in particular, we have to remember, when money comes out of an IRA, it's income.
Therefore, it's taxed. So what you've described to us so far has to do with traditional IRAs. How does the Secure Act affect a Roth IRA?
Another great question. The only difference between a traditional and a Roth IRA for purposes of the Secure Act is that when money comes out of a Roth, it is not taxable income. But unfortunately, the same accelerated withdrawals apply to a Roth as well. So the problem there is when the money is inside the IRA, it's allowed to grow and compound without being taxed along the way. And the fact that you have to draw the money out in 10 years, you end up losing quite a few years potentially of tax-free growth within the IRA, and that affects a Roth just as much as a traditional.
So therefore, how would somebody go about planning with this new law in effect when they're trying to grow their retirement fund, to plan their retirement fund?
Great question. And how do you leave the maximum to your beneficiaries? How do you leave the maximum impact of that IRA to your kids is what a lot of people are concerned about as well. One strategy, and this is something that you're advised to consult with your financial advisor and your CPA, is to check on your own individual investment strategy and your own tax picture, would be to consider a slow conversion of a traditional IRA to a Roth in retirement. In most cases, people's incomes have dropped in retirement. Their tax bracket goes down as well. And so they can, in a slow, measured way, convert a traditional IRA to a Roth so that when their kids receive that IRA, it still may have to come out in 10 years, but the good news is at least the income tax has been paid years before by their parents. That's one good strategy. Another really exciting strategy involves the use of charitable trusts. Without going too much into the weeds on this, if someone has a charitable desire and has a charity that they believe in and strongly want to leave part of their estate to, we can use what's called a charitable remainder trust to receive the IRA when that person passes, and through the application of the tax code, we can create a virtual stretch IRA using that charitable remainder trust to provide a stream of income to their children as they grow older. And then when their children pass away or at the end of a number of years, the charity they've selected receives what's left in that trust. So they can both help out their children and support a cause they truly believe in. For me, that's the most exciting solution to the problems of the Secure Act. The third path would be to invest in life insurance to hopefully offset some of the income tax hits of that IRA having to pay out in an accelerated manner, as well as make up for that tax-free growth that won't occur in the IRA. And those are probably the three most important strategies at this point for people to plan around the Secure Act to an extent.
So in summary, roll over slowly as the government outlines, because there's a threshold of how much you can move from an IRA or put into a Roth IRA annually. The other would be to use a charitable trust. Is that what it's called? Mm-hmm. And if I understood you with the charitable trust, I'm just using this as a number so that I can do math on the air. $100,000. It's set up for $100,000, and it's left to the kids. And over their lifetime, they could be withdrawing from that, and there could be $5,000 left at the end, and that $5,000 goes to the charity, correct?
Absolutely.
Okay. And then the third one, I just forgot what it was.
No problem. The third is using life insurance as a way to compensate for both the income tax and the lack of the tax-free growth.
So I don't think you just mean any life insurance policy. Is it like a universal life insurance policy, or is this something you talk to your insurance person about?
Absolutely. And with all three of these strategies, you want to be involving your estate planner, your CPA, and your financial advisor to work as a team to provide the best strategy for your particular financial situation. With the life insurance strategy, for example, it really does depend on your insurability, your age, whether or not you and your spouse want to pursue potentially a second to die policy. There are a lot of other variables, but life insurance itself does provide an exciting way to provide a benefit to your beneficiaries and counteract some of the effects of the Secure Act.
Okay. So now I had a question where I was wondering, is there a threshold that people should be concerned about as it pertains to the Secure Act? So for example, I'll use $100,000 again. What if a couple has they combine their accounts and it totals $100,000 or more? Is there any threshold with the Secure Act?
That's a good rule of thumb, Mary. And what we found in the estate planning world, in the early days of the IRA, people were putting in $2,000 a year. And for many years, IRAs were kind of an afterthought in the estate planning world. They weren't that large. They weren't a huge portion of people's estates. What we've noticed, though, is people have done 401k rollovers. So they've left their employer with a large retirement account, and they've moved those into traditional IRAs. we've seen the IRAs themselves grow in size and become, in some cases, the largest asset in someone's estate. And so what was once an afterthought in estate planning is becoming more and more the focus. And with the Secure Act now in place, what I would advise is for people with six-figure retirement accounts, like you said, $100,000 or more, to take a good look at what they've got in place for those retirement accounts upon their passing for their spouse, and then ultimately upon where that IRA is going to pass when both they and their spouse have passed away. And one word I would like to put out is that no matter what you've got in your will or trust, in almost every case, the IRA beneficiary form that you may have filled out years before when you first set up the IRA is what controls where that IRA goes. So it might be a good time for viewers to call their financial advisor, take a look at their IRA beneficiary forms, and make sure that form they filled out years ago still reflects their current wishes.
And a tip there, sometimes maybe you didn't fill out the beneficiary. Make sure that spot is filled in, because I know we have Roth IRAs, my husband and I learned this from you, and I sent him a text. Hey, have we named beneficiaries in our Roth IRA? If we haven't, we better make sure we do. This has been a wealth of information. We're almost out of time for today's episode. So what parting words of wisdom do you want to share with our viewers?
I would just like to share that, again, retirement accounts are something that we work for, we save towards, and as we enter our retirement age, they provide a steady stream of income and security for us. And they're definitely something that you want to take into account in your overall estate plan to make sure that that nest egg that you developed goes where you want it to go and who you want it to go to.
Thank you, Tony. So great information today. Make sure you're speaking with those professionals that are servicing you and helping you enjoy your retirement years, and making sure that you do have something left if that's what you would like for your family members and your loved ones. Thank you all for joining us today, Tony and viewers alike, and we'll see you next time. Have a great day.